Welcome, and thank you for joining us at today's Truth Project webinar. Before I hand over to our main presenter, I just wanted to say a few words about the project and why we are running this event. Today's session has been organized by the Truth Project, the partners from the UK Innova Consultancy and the Sheffield College. The Truth Project is funded by the European Commission, the Lifelong Learning Programme, and began in October 2013. We have been working with our partners from Italy, Romania, and Greece, and our main aim has been to raise awareness of the issue of human trafficking within our local areas and countries. And most importantly, our aim has been to provide an online awareness training program to frontline workers, such as social care workers, health workers, and police officers, who might all come into contact with victims and perpetrators, in order to ensure that potential cases are more likely to be identified. Of course, if you want to find more about the project, please do visit the website, which is www.truthuncovered.eu. As part of the awareness raising work of this project, the partners, we will all be delivering a short series of webinars over the next 3 months, presenting the Truth Project as well as wider topics around this issue. We're very excited as this is the first English language webinar, and I'm delighted to introduce Dr. Aidan McQuade, Chief Executive of Anti-Slavery International, to speak to us today about the UK's new Modern Slavery Act. I would like to hand over now to Dr. McQuade. Thank you.
I ask you all to unmute for a second and tell me if you can hear me and if you can see my screen?
Yeah.
That's grand then. I was asked to speak a little bit about the UK's Modern Slavery Act, and I thought to call the presentation the end of the beginning, which I hope will become clear as I speak. I've put modern in inverted commas, if you note, which isn't part of the Act. It's my addition because I frankly can't stand the term modern slavery, because I wonder what's modern about it. It's pretty medieval. The issue, the term I prefer is contemporary slavery, but others seem to prefer modern, so I suppose we're stuck with it. Just to give you a little bit of background of where this Act came from, I think the origins of it truly lie within the Anti-Trafficking Monitoring Group, which is a coalition of non-governmental organisations, which was brought together principally by anti-slavery some years ago in order to monitor the UK's implementation of the Council of Europe Convention on Action Against Trafficking in Human Beings. And that's done a number of very important reports, I feel, over the past 4 or 5 years, looking at different aspects of Britain's anti-trafficking policy and practice. One of the things which was identified in the course of the work by the Anti-Trafficking Monitoring Group by my colleague Clara Srivankova, working with a British barrister called Parosha Chandran, was that almost unbelievably, forced labour had never been made a standalone criminal offence in the UK. Whenever slavery was abolished in the UK in the 1780s by judgment by Lord Mansfield, he based that on Magna Carta. So his argument was essentially that because of Magna Carta, nobody present in the UK could be in a situation of slavery. Therefore, anybody who was in slavery was in fact immediately free. But it was never made illegal, it was never made a criminal offence, and in fact whenever the UK government moved to abolish slavery in the 1830s, rather, when the UK Parliament did that, what they did afterwards was they compensated very generously slave owners for the loss of their property. And on the back of the forced labour offence, there was a lot of new investigations carried out, and one of the things it uncovered, which was a thing I think which surprised many people, was the extent to which vulnerable British people were also being trafficked into forced labour within the very borders of this country. Previous to that, it was regarded as universally an issue affecting migrants. While it is still predominantly an issue affecting migrants, there is a significant number of vulnerable British people who are in forced labour up and down the country at the moment. Now, in parallel or subsequent to the anti-trafficking monitoring group's work, Centre for Social Justice, which is a centre-right think tank, quite closely associated with Ian Duncan Smith amongst others, it decided a few years ago, in order to undertake its own independent investigation into slavery in the UK. I feel it plundered shamelessly, showing its own wisdom, the work of the anti-trafficking monitoring group. Those who are more closely involved may dispute that, but I think there certainly was a strong influence of the anti-trafficking monitoring group's work on the subsequent work of the Centre for Social Justice. The Centre for Social Justice was in a position which was rather different from those of us involved in the anti-trafficking monitoring group, which was because it was so closely associated with senior members of the Conservative Party. Its report was maybe taken a bit more warmly by them, and consequently it was announced that there was going to be a UK Modern Slavery Act emerging out of the back of the Centre for Social Justice work. When this was announced, it was also announced that in order to help speed the process of getting the bill onto statute, a special committee under the chairmanship of Frank Field would be constituted to gather evidence. One of the strangest things in all of this process, as far as I was concerned, was that Frank Field's report of his committee, which whenever it reported, was reported on the exact same day that the government published the first draft of the Modern Slavery Bill, which suggested rather strongly that in spite of the fact that they'd sent up the committee with Frank, they hadn't actually read what he'd written. And the first bill was, I think it's fair to say, poor in the extreme. It was very heavily focused on consolidating slavery offences with no consideration of the victims of slavery, and some questions over whether some of the issues which were illegal within the UK were actually going to fall through gaps in the drafting process. And on the publication of the first bill, a second committee, a joint committee of the House of Lords and House of Commons, was set up again under Frank Field's chairmanship in order to gather further evidence for the bill. And it was off the back of the report of the second committee that the next draft of the Modern Slavery Bill was presented to Parliament. Now, that was a considerable improvement on the first one, but it was by no means the finished article. A lot of the strengthening of the second draft of the bill certainly came from the evidence that Frank had gathered, but not all of the recommendations of Frank Field's either first or second committee were incorporated into the bill, in my view, because they clashed too profoundly with the ideological perspectives of the government. So what to say about the bill? What's good about it? There is a consolidation of the law. There's increased the tariffs and penalties for those who are found guilty of trafficking and slavery. There is enhanced protection of victims, particularly for children. At the outset, I remember whenever I was at a reception, whenever Theresa May announced the bill, and the sense of contempt that there was for the notion that victims' protections were at all necessary was very palpable. Over the course of all of the evidence gathering, I think the government moved to a realisation finally of why victim protection was important, for a number of reasons, about not having somebody doubly victimised, both by the perpetrator of the crime and then by the law enforcement, which is meant to be investigating the crime. Secondly, because, quite bluntly, if you want to prosecute traffickers, you need witnesses, and the principal witnesses are likely to be the victims of trafficking, and if you do not protect them adequately, protect them humanely, protect them the way any civilized nation should be expected to protect victims of crime, then you're unlikely to get the prosecutions that you may desire. So that was some definitely major step forward in the bill. The next part, which was important, was transparency in supply chains. At the outset, again, the government wanted nothing to do with this, and they called in a meeting of a lot of leaders of British business, a lot of senior British executives who deal with, or whose businesses rather are members of the Ethical Trading Initiative. And the tenor of the meeting was, don't worry, there's nothing on supply chains in this bill. And it took a number of efforts by these business leaders before they could get the government to understand that they actually wanted regulation, because their efforts towards establishing clear ethical supply chains were hampered and undermined by competitors who had no such interest in this, and what they would like to see was a levelling of the playing field. And this, I think, was quite a considerable shock to the government, that businesses should actually want regulation. If businesses had not done that, there would be nothing on transparency in supply chains in the bill. It is, I suppose one shouldn't be too surprised about it, but the government now trumpets this as one of their great achievements and innovations within the bill, but it was certainly the last thing on their mind whenever they first published the draft bill. So those are positive steps forward in the bill. There are some problematic areas. First of all, is what's called the national referral mechanism, and this is an issue rather of practice and policy rather than of the law. But the national referral mechanism is the means by which the state recognises and identifies people who are victims of slavery. Its practice up until now has been deeply problematic. One of the pieces of research that the Anti-Trafficking Monitoring Group did a year or two ago found that if you came from within the European Union and presented yourself to the national referral mechanism as a victim of trafficking, there was a greater than 80% chance that you would be recognised as such. If you came from outside of the European Union and presented yourself to the national referral mechanism, there was a less than 20% chance that you'd be recognised as a victim of trafficking. That disparity in positive grounds findings, I think, can only be explained by institutional racism. Now, there is currently underway a review of the national referral mechanism, and the initial proposals from the government sound considerable improvements upon what's gone before. They've put in place an appeals process. They're trying to make sure that the decision-making bodies are multi-agency, multidisciplinary, so it's not just immigration officials sitting having a look at people's cases, but it's people from police, health and social services, and from non-governmental organisations. But that's not been put into practice yet, so we still have to wait and see how that's going to turn out. But the initial suggestions are quite positive. The next area is overseas domestic workers visas, which I'll come on to in greater detail in a moment. Then there's also the issue of non-disclosure loopholes in supply chains, lack of extraterritoriality in slavery offences. And I'll come on and talk to those two issues in more detail in a moment. But an underlying problem, I think, with the whole approach by the government to this issue is this one of a belief in organised crime, that the principal perpetrators of slavery in the world are organised criminal gangs under some Don Corleone-like mastermind. That sort of organised crime certainly is significant, maybe in some parts of the world more than others, and is an important aspect to the issue of slavery and trafficking in the modern day. But I don't believe anymore that it is the dominant factor. It is it's I think a significant minority of trafficking is dealt with by organized crime, and the majority of it is rather individuals taking advantage of the opportunities in the world for trafficking and for forced labor. No, so let me talk about the issue of overseas domestic workers. Overseas domestic workers are, as the name suggests, domestic workers from different parts of the world who are working in the UK. Up until 2012, they had the right to change employers. At 2012, that right was taken away from them. At the time, the government was warned that this was going to increase the risks of trafficking for domestic servitude for overseas domestic workers. The government said this isn't an issue and went ahead. They were happy with the protections that were in place. But those charities that deal directly with overseas domestic workers have found that there is indeed considerable new problems associated with tied visas for domestic workers. This isn't a new story. The tying of visas to employers across the world is a central reason, a central factor in allowing the enslavement of people, particularly migrant workers, in particularly low-skilled and other industries. And it is very much the case with overseas domestic workers working in the UK. I've made the analogy with the kafala system in the Gulf states, which is literally the sponsorship system. So migrant workers who enter the country have to have an employer sponsor them. Whenever they get into the country, the employer will generally take their travel documents and legally not permit them to change employer or leave the country without their permission. Generally, they will also change their terms and conditions, so they're not being paid as much as they were promised, and their living conditions are very, very poor. And this is the basis upon which the enslavement of tens of thousands of migrant workers for the construction of the Qatar World Cup. This is how it's provided. Now, the UK system of tied visas for overseas domestic workers is essentially a kafala system too, and consequently facilitates the enslavement of hundreds, if not thousands, of domestic workers across the country. It's one which doesn't make economic sense either, because if overseas domestic workers were allowed into the tax-paying economy, they would contribute millions to the UK economy. And this is work which it's almost impossible to get anybody but overseas workers to do. So it's not as if it's an unnecessary skill within the country. Now, there was various debates in relation to this during the passage of the bill, all of which the government robustly countered. When I say robustly, that was more to do with the vigour with which they countered the arguments rather than with the robustness of the intellectual arguments that were put in, because there doesn't seem to me to be, on human rights or economic grounds, any sensible reasons for maintaining this system. And yet the government seems to remain wedded to it. Now, they have announced a review carried out by a barrister called James Ewens to look at this issue, and he's gathering evidence at the moment. He's meant to report at the end of July, and we'll see what he says. However, this would be, I think, the 5th review in the past 2 years of overseas domestic worker visas. The House of Commons Human Rights Committee, the first Frankfield Committee, second Frankfield Committee, Centre for Social Justice, all looked at this issue, all advised that this is deeply problematic from a human rights perspective in terms of facilitating slavery, and yet the government has not been swayed by those arguments. So I don't know how James is going to report, but I would not be too hopeful that if he was to come to similar conclusions as those previous four reviews of the visa, that the government would accept that and change the rules as they currently stand and end the British kafala system. Now, the second issue, which is quite problematic, comes back to this issue of transparency in supply chains. And as I mentioned, the only reason that clause is there in the first place is because of the pressure applied to the British government by business itself, because most businesses, particularly those with international supply chains, are quite aware of the problems of forced labour within those supply chains, particularly whenever those supply chains are working into poor and undemocratic parts of the world where there are issues with rule of law. The photographs you see on the screen of four young women, these four young women who had been textile workers under a system known as Sumangali. Sumangali is recognised as by the Indian courts as a form of bonded labour. It's a practice by which young women and girls are promised that for 3 years labour within a factory, they will receive at the end of that time a lump sum which will be sufficient to afford a dowry and hence get married. But what they find is that the terms and conditions by which they've been promised are considerably poorer than that which they had been led to expect. At the end of the time, they may not get the lump sum for spurious reasons, which the company uses in order to deny them it. Oftentimes their health will have been ruined as a result of that work from inhaling of cotton dust and poor nutrition during those times. And essentially their job is to spin into cotton thread, Indian cotton, for which is then used in order to manufacture garments across southern India in particular, or to manufacture material which is cut and sewn up in other places. It's such an extensive system that I guarantee you that if you go to any shop up and down the country, there will be within that lots of garments which have been manufactured by the forced labour of young women such as these. And probably all of us, if you think about other systems of forced labour within different parts of the garment supply chain, every single one of us who are sitting on this call at the moment will be wearing at least one item which is tainted in significant part by the enslavement of vulnerable people in some part of the world. Just to give you a sense of just what that means in human terms, we spoke to one mother of a textile worker in southern India a few years ago when we did some research which broke open this story to a large part of the world. And she was describing about meeting her daughter who was working in the mill, and she said, I spoke to her in a room provided for visitors because visitors are not allowed to go inside the mill or the hostel where my daughter stayed. My daughter told me that she was suffering with a fever and vomiting often. I met with the manager and requested him to give leave to my daughter because she was unwell. I told him we'd send my daughter back once she was better, but the management denied, saying that there was a shortage of workers, therefore they cannot grant leave. He also assured me to take care of my daughter and asked me not to worry. A week later, of course, she received the message that she could collect her daughter because at that stage she was already dead. She was 20 years old at the time. Some of you may have seen recently the reports in The Guardian, which we worked with The Guardian on, about slavery in the Thai fishing industry. These are two examples of supply chains which feed into the consumer goods and services that we buy on our own high streets. As I said, businesses who work internationally know about these risks, and hence the reason for their support for greater transparency of international supply chains. One of the things we discovered just before the bill, a few weeks before the bill was actually passed, was that the government had stitched a loophole into it, which meant that if you have a company which is a wholly owned overseas subsidiary, you don't have to report on what that bit of your business is doing in relation to trying to combat slavery and forced labor within that particular part of the supply chain. So you could set up such a company if you were of a mind to, set it to work in some part of, say, the Middle East, say Qatar. You would never have to report in line with this bill on what was going on in Qatar, which would most likely involve slavery and forced labor in some aspect. And if you were a business executive overseeing that work in clear knowledge of what was going on, slavery, offensive slavery within this bill is not extraterritorial, so you would never be prosecuted for what was going on in your supply chain there. I think these provisions were put into the bill deliberately in order not to scare off some of the Conservative Party's more favoured donors who may well be profiting or worried about forced labour within their supply chains. And it is an area of the political economy in which some of the most egregious forms of contemporary slavery exist today. So a couple of things just as I finish. The first one is an issue which is sort of topical at the moment, which is this issue of smuggling versus trafficking. Many European politicians at the moment are talking about the traffickers in the Mediterranean, and are saying because they're such great advocates of anti-slavery that they must use military action against them. We need to be clear about just what these terms mean. First of all, trafficking is about the movement of people into situations of forced labour. Smuggling is about helping people get across borders illegally. Some people who are trafficked are smuggled. Some people who are smuggled are not trafficked. What we're generally seeing across the Mediterranean is smuggling on an enormous scale. But the language of trafficking is being used, I think, for quite cynical ends in order to justify the idea that military action against the fishing boats of Libya is something which is not only necessary but also imperative. It doesn't. The whole what's going on in the Mediterranean at the moment certainly would give great opportunities for traffickers, but the underlying problem is not the fishing boats of Libya, but a variety of other factors, including the wars of the Middle East, North Africa, and including the lack of safe migration options for refugees from those wars. And none of those factors are going to be addressed by military action against Libya, but the use of the language of trafficking and slavery provides European political leaders with a veil behind which they can prepare and enact their military adventurism. The consequence, though, for this part of the world is interesting, because one of the things which lawyers find is that juries have great difficulty bringing in decisions on cases about trafficking because they're so confused about what it actually means. And it's ironic that one of the politicians who has been quite vocal about this issue of the traffickers of the Mediterranean is Theresa May, because whenever she brought in the modern slavery bill, one of the things she was saying is she wanted to see increases in prosecutions and convictions of traffickers. And the way she has been using language of trafficking over the past few months has unquestionably contributed to future confusion that juries will feel whenever these cases are brought. So she's been undermining, by her language, that which she says was her ultimate purpose. Ending slavery in the end requires not just law enforcement approach, but transforming the global political economy. And by the political economy, I mean the laws, governments and customs by which we regulate employment, production and trade. That means new approaches to law enforcement, to trade, to aid and to diplomacy. And particularly to aid, I think, because very rarely is the question of slavery considered as part of international development aid. Too often these days, international aid is being regarded as putting into the hands of people who don't have things, putting things into their hands. It's about technocratic transfer of stuff. When the bigger question is, why don't they have things in the first place? What are the political processes which are keeping them out of the power structures which exist within their countries? And slavery and discrimination are two of the big factors which exclude from poverty reduction measures large swathes of the population. And until the focus is shifted onto those parts of the population, I think we'll have great difficulty making any headway against the issue of slavery in the world. So that's about all I have to say at the moment. Hope that has been in some ways useful to you.
Thank you. Thank you very much, Dr. McQuade. So now I'd like to invite you, the audience, to ask any questions to Dr. McQuade, please. We'll try to see if we can do it using your microphone. If there's a lot of background noise, then we will use the text, the chat. There's some comments coming through the text box, Aidan. Can you see them? Julia is asking, hello, could you possibly comment on the defense for slavery or trafficking victims who commit an offense?
Yeah. Let me just get this. Yep.
Okay, then. All right, bye.
The defense of slavery basically in international law and in general good practice, if someone is compelled to commit a crime, they shouldn't be prosecuted for that crime. There's obviously been some considerable concern from government and others about introducing that blanket defence. The nightmare scenario which is often recounted is, suppose you are a cop who kicks down the door of a cannabis factory and the person who owns the factory knows that this defence is in place and so hands a gun to the children who are generally enslaved there to use in any cop coming through the door with the promise you won't be prosecuted. So this was the argument for a long time from the government against that. The government has since endorsed the Forced Labour Protocol of 2014, which includes this idea of non-prosecution within it. And what's reflected in the Act is essentially what's in the 2014 protocol. There is, in addition to that, a long list of crimes for which you can't be prosecuted and those for which you will be, which is, I'm not sure if it's part of the Act or if it's part of the, or it's going to be part of the guidance alongside that. But even with that, I think the government's felt the need to be quite prescriptive about some things which you may still be prosecuted for. So it's been described by some barristers, most notably to my mind Parosha Chandran, as a trafficker's charter, because here's the crimes for which you can import people to commit now.
Thank you very much. I had to mute everyone because there was a lot of background noise. So if you have any questions, can you please add them to the chat? Oh, there's another question, Dr. McQuade. Can you read the chat box?
Do you think this new act will be the main driver for companies any size to look at their supply chains and its transparency? Are there any other initiatives to play a part in transparency of supply chains? Well, I'm going to take the last ones first. The transparency element in the UK Act is inspired, I suppose, by the Californian Transparency and Supply Chain Act, which is also inspired the beginnings of federal law. And what both those laws and the UK law require is that companies which are trading into the UK or California or whenever it's past the United States will have to report on their supply chains, even if they're not British or American or Californian companies. So that's certainly that grouping of laws are certainly drivers towards greater transparency, and there was a feeling at the outset of the discussions here that there should be some alignment with, in particular, the Californian law, which is the first one, in order to enhance the impact of that law and to receive the complementarity for it, because companies are already reporting on that. There is a process ongoing at the moment which is about then turning the intent of the supply chains clause into regulations and rules and guidance for companies. And the greater, I think one of the important parts of the discussion is about at what threshold level you set the level upon which you have to report at. What size do you need to be? And there's been increasing thinking, increasing argument, which I feel is beginning to win the day, that the threshold should be set lower rather than higher, for the reason that one should be trying to create a critical mass of businesses who are engaging with these issues and reporting on them, and learning from each other about that. So I think once you start getting companies beginning to do that, that will become an even greater critical driver towards greater transparency. All that said, with the caveat that there is this loophole, and if you are a company which is doing business in some particularly dodgy part of the world, if you set up an overseas subsidiary, you don't have to report on anything within that subsidiary. And so that is going to be a constraint on reporting. Now, a legitimate way of filling out your entire report would be answering the question, what is your company doing about forced labor in its supply chain? And the answer, nothing, is fine. It fulfills the reporting criteria of this and of California. I think in the end, what we need to move towards is some proper sanction for companies which are knowingly profiting from slavery. I think one of the first things that we could look at would be excluding from British and European markets the products which are demonstrated to be produced using forced labour. I think thereafter we could start talking about criminal liability for business executives who are knowingly profiting from the use of forced labour in their supply chain. And I think those would be quite robust measures which would begin to drive even greater change within the supply chains of businesses. There's another question which is from Marina. How does UK legislation with regards to this issue compare to other EU countries? I think it is the first, the Modern Slavery Act is the first act of its kind in Europe, certainly. Within it, I mean, the government says it's world leading. I'm not sure if that's wholly supportable. I think there's probably other countries which have got more piecemeal pieces of law which gather together into a body, which is a body of work, a body of law, which is maybe more comprehensive in dealing with the political economy. That was certainly my feelings about the UK up until 2010. If you looked at the body of law and regulation which had been brought in by the previous government, I think it was beginning to grapple some of the significant issues there, though there was unquestionably big problems with that as well. And I imagine the last government, or the government before last rather, would have been as resistant to the idea of regulation of international supply chains as the previous one has been. I suppose the most important piece of European law in relation to this at the moment is the EU trafficking directive, which is British law at the moment, but I'm not sure how much of it has been translated into UK national law through this particular act. Within the trafficking directive, there is talk of liability of legal persons, by which they mean companies, but that's not something which has been tested or worked out in court yet. So, so that's, I think, one thing which needs to be looked at more in the coming years. I think that's about as much as I would say. I think victim protection, though, in other parts of Europe is somewhat better than it still is in the UK. I think Germany and Italy still would have better victim protection than the UK, but there's certainly been important strides with the UK over the past with this bill. So, Tina asks, I am concerned that the news reports and the people smuggling happening in the Mediterranean is continually wrongly reported as trafficking, leading to the public confused. Is there any pressure being put on journalists and broadcasting companies to use correct terminology? Apart from myself tweeting at every recalcitrant journalist who confuses those terms, and I published an article in The Guardian 3 or 4 weeks ago about this, I'm not really clear about anybody else who's doing much on this. It is very frustrating. I think the confusion in the language is something which politicians are cynically doing. They certainly should be known better, but it plays into their political agendas. So I think it would be something anybody on this call, whenever they see it, call out the journalists who are doing it, point out why they're wrong, and the consequences of it. There was a letter which was prepared by academics in the US and the UK, which I, amongst many others, signed on to, which was published yesterday, on criticizing this confusion between trafficking and smuggling, and how the lessons of history are being twisted in order to justify contemporary military action. That seems to have caused a bit of a stir today. So hopefully it'll cause more stir and other people will sign on and endorse that position. Julie's just commented, Tina, in a research that you did, found that the same confusion exists in the media in other EU countries. So Poland also has got that confusion in language. So yeah, I think the more of us across Europe who can, call our governments and our journalists to account on this confusion between trafficking and smuggling, I think the better.
One last question before we finish this webinar, before we end the webinar.
Sure.
Any more questions? I just wait one couple of seconds in case somebody's typing. But I don't think that's the case. Oh yes. This just came a message from Tina.
Yes, what I can do is I don't know if anybody can see my screen at the moment.
Yes, yes we can.
There is the Guardian report on the letter, which I can just post the. I've just posted the web link there to that, and I'll just also post the web link to the article that I myself wrote on this a little while ago, because nobody else reads my stuff. So there's two pieces, and there's some links within each of those articles which will lead you to the references and to other sources within them. So I hope those are helpful. So Carol, I think you said you believe individuals are the main perpetrators rather than organised criminal gangs. Did you understand? You understand that correctly? Do you have any stats references? Interestingly, I don't have them to hand. It was an instinctive feeling that I have whenever you look at the global issue of trafficking and forced labour. Whenever you're thinking about the questions of looking at things like trafficking of South Asian workers into the Gulf states, I suppose if you look at some of the practices of some of the construction bosses in Qatar, you could say yes, that's organised crime. But I think the understanding that people have of organised crime is generally something which is illegal, not just immoral, or is more hidden rather than so publicly in the open. So my comment was essentially a global one about the international political economy rather than a domestic thing in relation to the UK and sex trafficking. However, having said that, there has been some work done by Jean Alain and some other academics, some of them may even be associated with Sheffield, looking at networks and trafficking for forced labour. And one of the things which comes out of that is that even amongst the so-called organised crime, what you're actually looking at is something much more akin to a market economy, with small traders engaging with each other to supply different aspects, rather than sort of this vast criminal enterprise of somebody sitting in London enormous immoral earnings while his minions go running around the place. So it's more a small trader model rather than a corporation model, if that makes sense, I hope. And the second thing then, which I don't think has been published yet, but about 4 or 5 weeks ago I was at the Home Office where they presented some of the a meta review of the research which had gone on in relation to trafficking, and it was announced at the end of that, it says it does seem that trafficking is something which in the UK is something which is carried out by individual opportunistic crime rather than this vast conspiracy. And the comment which was made immediately after that was, you know, obviously the government believes that this is an issue of major organised crime, so this research itself, the evidence upon which we've based this research may well be biased. So there was a desire to put I would take it as an ideological perspective upon the extant research in order to uphold that governmental position. It was a bit of a confused answer, Carol, but I hope it touched some of the basis of the questions that you asked.
Okay, I'm afraid we don't have a lot of time left, and I just wanted to thank you on behalf of the Truth Project, especially Aidan. We are very grateful to have you with us today, and thank you for a very comprehensive and interesting presentation. We have recorded this webinar and we'll make it available and we'll send a link to all of you and as well to people that wanted to participate but unfortunately couldn't make it. We'll also make it available. I am sharing with you the link of the project, truthuncovered.eu, if you want to, as well to find more information about the coming webinars. Thank you very much to all of you, and everybody have a good day.
Thanks very much for having me. It's been a pleasure.
It has been fantastic. Thank you very much.
Bye-bye.
Bye-bye.